Good morning, everyone. Good morning, Advocate Batohi.
Good morning, Judge, and good morning to all.
Good morning, Andrew Chauke. We have been informed that you ultimately managed to the printing. We hope that they will replace these printers that are giving us problems. Advocate Nkabinde, did you manage though?
Yes, Madam Chair, we have managed to print. If I could ask my colleague to hand them up. I'm not sure if there is one for Advocate Batohi. Huh? Yeah, there's one.
You may start, Counsel Advocate Batohi. You are still under oath.
The chairperson.
All right. Thank you, Madam Chair. Advocate Batohi, good morning.
Good morning,
Yeah.
Counsel.
Could I start with a recap of your evidence from Friday? When I asked you questions about the email from Inspector Danikas dated the 7th of August, 2019, you initially stated that you have no recollection of receiving the email. Later on, you stated that Advocate Mzinyati should have brought the email to your attention given the high-profile nature of the matter. In fact, your actual answer is, well, it should have been brought to my attention given the high-profile nature of this matter. You remember that?
I do.
Thank you very much. And then when I asked you again, you said, as I said, given the high-profile nature of this matter, it should have been brought to my attention. But Advocate Mzinyati thought it best to forward it to the DPP KZN, correct?
That is so.
Then I continued further, where I said, was it appropriate or not to bring it to the attention of the NDPP? And then you said, perhaps it was an oversight on his part, correct?
That is so.
Yes. Now, it is in that context that we asked, and we are grateful actually to, I think it's Advocate van Rensburg, who has been able to find these documents for us. It's in that context then that I want to ask you to look at page 354 of the bundle that's been handed up to you. 354 is the cover page.
Yes, I'm there.
Yes. Now, according to this, on the 8th of August 2019, Ms. Bulelwa Makeke forwarded the email of Mr. Danikas to you at 9:14, correct?
Yes, I see that.
Yes. So you would therefore accept that this email was brought to your attention?
Yes, I see that.
Yes. Now, we can then see also that what we didn't have in the document that we gave you page 357 and 358 on Friday. But what Advocate van Rensburg has also been able to track is page 359. Can you see that?
I do see that.
Yes. Now, I don't want to read page 359 because it has a lot of expletives, but you would agree that it contains more abusive language from Major General Boyson directed at Mr. Danikas.
Yes, I agree.
Yes. Now, could you then explain yourself why a witness who is being threatened and intimidated and abused has reported it to you personally, you have not taken action to protect that witness?
I can't recall what precisely happened at the time in 2019. I see that the email was forwarded to me as well as to Advocate Mzanyati and Advocate Matska, who was the in the NPS at the time. And I cannot recall what exactly happened at the time. And it will be speculative of me to try to answer that now. There are instances when matters are referred to me, and if the deputy national director is copied in there, I expect that they will in fact attend to it. And I can only imagine that that is what happened in this case.
Now, you see, the problem with that answer is that we went through that on Friday. And on Friday, you said that there was an oversight on the part of Advocate Mzanyati for not bringing it to your attention. You said that twice. And that's why Advocate van Rensburg's discovery is very important, because it shows that there was no oversight. The matter was brought to your attention directly. And that's why I have to ask you again, why did you fail to protect a witness who was being threatened and intimidated by a criminal accused?
It wasn't a failure to protect, because as I said, I can't even recall seeing these messages. I can only say that I would have expected Advocate Mzanyati, given that it was sent to him as well, as a deputy NDPP, to deal with it. But I did not see the contents of these messages at the time.
I'm not sure I understand. The email is sent to you. It attaches abusive content. It is criminal in nature because it amounts to witness tampering. You then claim that you did not see the contents. I find that remarkable. How could you not see the contents of an email that has been sent to you?
As I said, I don't read all the emails when a deputy national director is copied or is also it's sent to him or her. I would often leave it to them to deal with the matter as appropriate. And that is why, in this case, I would imagine I would have done the same.
Are you saying that when you said on Friday that this should have been brought to your attention, and I was certainly of the impression that it was not brought to your attention, now we know that it was brought to your attention. Despite all of that evidence, today you are saying you did not read it.
Today I'm saying that I would have left it to the deputy national director to deal with it, and I didn't look. I've not, as I said, I've not seen these messages, so I would not have read it at the time in 2019.
That I don't find difficult to understand. If you look at page 354, it is clear there. Good afternoon, Ms. Makeke. Kindly pass the letter to the attached, this letter to the head of the National Director of Public Prosecution, Ms. Shamila Batohi. Your name is written even in bold. It's clear that it is intended for your attention. And you say, no, I did not read the email at all.
There's a lot of matters that are sent for my attention that the deputies deal with. That's all I can say.
I beg your pardon?
There are a number of matters that are sent for the National Director's attention that the various deputies would deal with.
Can I just ask you a few questions around the answer you have given? What the facts show is that the complaint by Mr. Danikas was brought to your personal attention, correct?
That is correct.
Yes. What the facts also show is that you knew that Mr. Danikas was a witness, correct?
That is correct.
What the facts also show is that you knew that Mr. Boyson was an accused person.
That's correct.
Yes. And therefore, what the facts show us is that an accused person had contacted the witness, which on Friday you considered would have been illegal, correct?
That's correct.
We also know that you have an obligation as the NDPP, as the head of the NPA, to prevent the conduct of Mr. Boyson in potentially intimidating a witness, correct?
I have many obligations as a national director, but it doesn't mean that I deal with all of them personally.
I don't think you're answering me. I'm asking you whether or not you admit that you have an obligation as the NDPP to take action to stop the conduct of Mr. Boyson in intimidating and threatening a witness.
As I said, the national director has many obligations. It doesn't mean that he or she deals with it personally. In this case, in these circumstances, perhaps they should have dealt with it differently.
I don't think you're answering me. What I'm putting to you is that you have a legal obligation to take action to prevent the intimidation of a witness by an accused person. Do you admit that or do you deny that?
I'm not denying it. All I said is there are a number of obligations that a national director has, but it doesn't mean that he or she will deal with it personally.
Yes. What is the answer to my question? Do you admit or
That
deny?
is my answer to the question.
Well, is the answer yes or no? You either have the obligation or you don't have the obligation, or maybe you don't even know that you have an obligation like this.
That is my answer, and that's as far as I can take it.
No, I'm afraid, Advocate Batohi, you cannot get away from answering whether you know the extent of your obligations. You've been the NDPP for too long for you not to know your obligation. I put to you again, do you admit or deny that you have a legal obligation to prevent the conduct of Mr. Boyson in intimidating a witness?
I would say that as prosecutors, we must do whatever is necessary to prevent intimidation of witnesses.
Again,
I beg your pardon, Counsel. The question is directed to you as the head of the NPA, not directed to prosecutors. I think answer the question. Directed to you as a head.
Chairperson, as I said, if there's any allegations of witness tampering or intimidation, then yes, as the national director, you would be expected to look into it. But as I said, the national director has many obligations. It doesn't mean that he or she has to deal with it personally.
so the answer to my question is yes, you admit that you have the obligation I've described.
Yes.
Now, on the facts, you did not take any action yourself, any action. You did not even ask Advocate Mzinyati to deal with anything. You took absolutely no action to fulfill this obligation.
As I mentioned, if you look at it, Advocate Mzinyati and Advocate Matska, who was his immediate, who reported to Advocate Mzinyati directly, were both, this was sent to all of them, all of us, I should say. And in the circumstances, I get many emails like this, and where the head, the deputy national director, it's also sent to him, I expect that they will deal with it.
You see, this is, and I don't want to constantly accuse you of giving evasive answers and lying under oath. On Friday, you told us that there was an oversight on the part of Advocate Mzinyati for not bringing this to your attention. You also told us that given the high-profile nature of this matter, it should have been brought to your attention. And for you today to say that they were correct in not bringing it to your attention seems to me to be inconsistent. And I say, I don't want to go there again. And I want to just ask you again the question. I do not see any evidence on everything we've been sent by Ms. Karen van Rensburg that you personally took any action to fulfill this obligation.
I have to again state, a national director has many obligations, and it is not expected that he or she deals with everyone personally. In particular, when a deputy national director a communication is sent to him as well, I would often leave it to them to deal with the matter as appropriate.
Advocate Batohi, I must repeat my question. I have not come across anywhere in these documents that you personally took any action to fulfill the obligation you admitted you bear.
I've answered that question.
Well, I'm not sure if I understand the answer because you've answered it by evading it. And I repeat it again. I have not seen any evidence that you personally took any action to fulfill the obligation you admit you bear.
I am not evading the question. I have responded that it is not expected of a national director, particularly in these circumstances where a deputy national director, it's sent to him as well to deal with the matter personally. So in this case, yes, I did not deal with the matter personally.
Yes.
But the deputy national director it was addressed to him as well. So
yes,
he has the delegated authority to deal with these matters.
Yes. Now, I can ask you now about the deputy national director. He also took no action.
Council, before you proceed, sorry to interrupt. Advocate Batohi, you keep on saying the NDPP has a lot of responsibilities that she deals with. Just to satisfy my curiosity, because we know from your evidence that you do not read dockets, and now this morning we know that you do not read all the mail that you receive. Can you just maybe enlighten us on the type of work that the NDPP does that keeps an NDPP so busy that she can't even read her emails that are sent to her inbox? Thank you.
I'm not saying I don't read emails. I read my emails, but where a deputy national is copied, I expect that they will deal with it. So if you want me to set out what the functions and roles of a national director are, it starts from the strategy. And so we have to look at what is the strategy of the NPA. And of course, the national director is responsible for implementation of the strategy. The strategy has various different aspects to it. And that would include, whatever the strategic objectives are. And they would relate to, at a high level, dealing with prosecutions, dealing with asset forfeiture, their access to justice issues. So there's a whole lot of high-level strategic objectives, and these are broken down into plans. And in addition to that, we have a number of, the NDPP is responsible for, in addition to what's in the strategic plan in terms of performance of the organization, etc., there's a number of strategic initiatives that we undertake in terms of what we refer to as our IPAC values: independence, professionalism, accountability, and credibility. And there are a number of strands that fall under that, that we are, for example, under independence. I can talk about a number of things that we deal with there. Professionalism deals with staff-related issues, a whole range of issues relating to capacities, capabilities, integrity issues. And then there's the issue of your reporting obligations to Parliament. There's the issue of dealing with sorry, I'm just trying to think. The reporting obligations to your stakeholder management is a big part of it, dealing with external stakeholders, attending to various stakeholder and other meetings, and then, of course, dealing with reviews that may come upon your table, representations, and etc. I think in order to be completely holistic, it might be advisable for me to write it down and send it to the panel so that they have a good idea of what exactly occupies the National Director.
As a follow-up, in all the duties and responsibilities that you have mentioned, I didn't hear you once talking about anything to do with litigation. You talk about strategy, and maybe also assist me. You keep on talking about high level. I don't know what that high level means. If you can assist.
The NDPP does not get involved in litigation as such, in the sense that the NDPP does not prosecute him or herself. Where the NDPP is cited as a party in litigation proceedings, we have a legal affairs division that deals with that. High level, I'm not sure in what context to answer that. I don't understand the context of the question.
You said strategic implementation at a high level, and this is not the first time that you use the term high level when you answer a question. So I'm trying to understand what you mean by dealing with issues at a high level.
It's important for a national director to actually focus your initiatives at a strategic level, generally. The operational matters are dealt with colleagues that are below the national director. And to the extent that you need operational reports, these will be submitted to the national director.
Thank you.
Yes. Advocate Batohi, we are still dealing with Mr. Danikas. Now, I put it to you that even Advocate Mzinyati never addressed the allegations of witness tampering.
It appears so.
Yes. Now, I come back then to this issue. On the common cause facts, you took it up yourself personally, the whole matter of General Boysen and Cato Manu, including appointing a panel and withdrawing the charges, writing a letter to the DPP telling them that there are no sustainable charges, even on the predicate offenses. Why were you not interested in allegations against General Boysen? To say, I did not read the email, strikes me as if you didn't care.
That's not the case. With regard to the Cato matter, I dealt with it personally because there was litigation, and I, as the national director, needed to understand and take a decision in that litigation. So it was important that I dealt with it personally. As far as me sending it back to the DPP,
I beg your pardon, Council. Please repeat what you've just said now.
Chairperson, there was litigation before the court, and then there was a review of the decision of Advocate Abrahams, the authorization for the racketeering charges. As a national director, I needed to decide what our approach will be in those review proceedings. So I needed to therefore personally get involved in order to decide, make a decision about the position we'll take in those review proceedings. And that is why I had to appoint a panel and get involved in the matter personally, because it was a decision I had to take myself. As far as the...
Before you get there, if my recording, my writing is correct, you answered to my sister that the NDPP does not get involved in litigation, something to that effect, because you have legal affairs. Now, what you've just said to me seemed to be inconsistent with that earlier statement. Am I correct?
No, Chairperson. What I meant is that the NDPP there is a legal affairs division that deals with litigation. But there may be instances when the legal affairs division will need to get direction either from the national director or from the EXCO in terms of what is the position that we take in particular litigation. It depends on what exactly the litigation is about. So they don't always do it, but in some instances they would seek the view of the national director or the EXCO. So to that extent, you will need to give direction to the legal affairs division. So the sense I meant is that the NDP doesn't actually get involved in the litigation in terms of, the processes that unfold in those litigations, yeah.
It is common cause that these matters, particularly the Katumena matter, has a checkered history. When you took office early in that year, 2019, these matters had been ongoing, and you took office and found that there had been certain developments relating to the very matter that concerned Major General Boysons, correct?
That is correct.
And as you got involved personally in that litigation, the review application, didn't you then deem it fit to personally look into the history of the matter that might have given rise to the very application that Major General Boyson launched?
Chairperson, by appointing a panel to deal with the matter, I was in fact dealing with it in a sense personally, because I appointed the team to look at all of the evidence and to give me a report to enable me to make a decision. And in my view, that was dealing with the matter because I had to take a decision. But it didn't require, in my view, that I personally deal with it to the extent of reading every single docket in this matter and then personally attend to it in that way. In my view, I did give it the necessary attention in the circumstances.
The matter concerning the email communication from your communication official, Ms. Bulelwa Makeke. It arose last week.
That's right.
My understanding, and correct me if I am missing the point, what you said was that you did not receive the email. Is that correct?
As far as my recollection is, I couldn't recall having received it because I couldn't, when I saw the email, I couldn't remember it. So I assumed I did not receive it.
The issue concerning the involvement of Advocate Nzinyati was mentioned by you when you said that there might have been an oversight on the part of Advocate Nzinyati not to bring the matter to your attention. Am I correct?
That's correct.
And if that is so, is it correct that had Advocate Nzinyati brought it to your attention, you would have reacted to it? Because that answer, that gave rise to the need to have the emails, was on the assumption that the email had not reached you and that it was an oversight on the part of Advocate Nzinyati not to bring that to your attention, which presupposes that had you been aware of the communication, you would have acted upon it?
Chairperson, given what I was dealing with at the time, I would have asked him to look into this matter a little more closely, perhaps. And I'm trying to, cast my memory back now and state now what I think I would have done at the time. And that's what I would likely have done, is asked him to look into it. Because as I said, I didn't see these messages. I can't recall anyway having seen it at the time. And given that the matter was being dealt with, I would have asked him for some response to this, perhaps.
What are you saying, Advocate Batohi?
What I'm saying, Chairperson, is that had I been aware that there was witness tampering at the time, I would likely have asked him to have looked into this and sent me a report about this particular aspect.
How could you have known about that when you did not even read the email?
That is correct, Chairperson. I didn't know about it.
The question is, how could you have known about it when you did not read the email?
I didn't, Chairperson. That's why I said I've seen it now, these messages, for the first time.
And you've just answered that Advocate Nzinyati himself did not do anything.
I don't think he
I
didn't.
beg your pardon.
Apologize.
He did not do anything about the issues concerning witness tampering.
That appears to be the case, Chairperson.
What should we make of that as regards your leadership?
As I said, Chairperson, there are a number of matters that come to a National Director's attention. And whenever a deputy is copied in it, I expect that he will attend to it appropriately. And that is what I did in this case.
I understand that, Council. What I'm asking you, and you might assist us, what should we make of that, given the fact that, first of all, the email was addressed to you. Secondly, nothing was done about what appears to have been witness tampering or constituted witness tampering, and nobody did anything about that. My question is, as the head of NPA, what should we make of that, particularly as regards your leadership of the NPA?
Chairperson,
Because I'm asking this question, Council, and I'm asking it because the buck stops with you as the head. It may well be so that there's sometimes a delegation of powers, but the buck stops with you, particularly when an email of this nature is addressed to you. So what should we make of that?
Chairperson, as I said, indeed, the buck stops with the National Director for everything that happens in a rather large organization of over 5,000 persons. It is not expected of a National Director to deal with every single matter that comes across his or her desk. There are a number of people that have delegated authority, and in that sense, it's perfectly reasonable for a National Director to expect very senior people, and we're not dealing with junior people, we're dealing with very senior people, including DPPs who have legal authority to deal with matters in their divisions, to address the matter. So it's not unreasonable of a National Director to expect that these very senior people will attend to matters correctly.
Is there a formal delegation of powers by you to prosecutors such as Advocate Nzinyati to do certain functions that are supposed to be done by you?
Chairperson, there are, in terms of the Act, a Deputy National Director can do this, has the same powers and functions as a National Director. But with regard to particular functions, there are specific formal delegations. Otherwise, they are responsible for everything that falls within his area of his business unit, should I put it, his or hers.
In terms of reporting and accounting to Parliament, if this matter were to arise in Parliament, were you going to tell Parliament that this function was delegated to somebody who did not do what he was supposed to have done, particularly when it is clear, as you indicated earlier, that there was witness tampering? Would you have said to Parliament, I do not execute such functions because these kind of matters are normally within the responsibilities of the DPP or somebody, your subordinate, whoever it is?
Yes, I would have, Chairperson.
And if this person failed to do what he ought to have done, as you indicated earlier, what would then happen to that advocate?
Depending on what the issue is, the National Director should ensure accountability.
Now here, you've just mentioned that Advocate Nzinyati failed to address issues of witness tampering. Is that not serious to warrant an action against such an advocate?
I will look into the matter, Chairperson, and consider what steps I could potentially take to understand what exactly happened in this matter.
No, I'm just asking, as a matter of principle, if such an official or an advocate failed to act or address serious issues where there has been witness tampering by an accused person, what should then happen?
The National Director.
What ought to have happened?
The National Director should seek, firstly, a report from the staff member concerned to understand what happened in the matter.
Now, between 2019 July or August, when this email was sent to you, until today, what steps have been taken against Advocate Mzinyat for failing to act?
Chairperson, none, because I cannot recall that I was fully aware of what happened in this matter.
Are you saying that between 2019 August until today, you have not acquainted yourself with the happenings in your office?
That's not correct, Chairperson.
I beg your pardon?
That is not correct.
What are you saying?
Between 2019 and now, I've certainly been acquainted with a lot of the happenings in my office. But in this particular case, I was not aware of what had happened with regard to this aspect of it. Yes, that's what I'm saying, Chairperson.
And this aspect of it is contained in a communication to the NPA concerning, among others, serious allegations against Major General Boysons, which impacts on the administration of justice.
It appears so, Chairperson.
I have a follow-up.
Chairperson, there was another aspect of question that I didn't answer, and I don't want to forget to deal with that.
Council will go back to that question.
I have it written down. I just want to respond to it.
Yes, we are still asking you questions. You'll go back to that question.
You, when asked about the fact that Advocate Mzinyati did nothing about the complaint that you received on the 8th of August 2019, you said clearly something needs to be should be done to deal with that. But I'm wondering, because your answer is where you receive an email and a deputy, one of your deputies is copied. You don't read that email, meaning you won't know what the email contains, and you will not know what steps were taken to remedy what is in the email, and therefore you will not take any steps if the remedy was not done or the email was just ignored, because you do not know the contents of the email as per your previous answer.
As I was saying, I'm dealing with very high-level senior members in the NPA. And with the number of matters that I get across my emails, it would happen that a deputy, especially if a deputy is copied in, that I would expect that they would deal with the matter appropriately. And as senior members of the NPA, they are aware of when they need to bring something to my attention. That is what they're expected to do. So I expect that they will deal with it appropriately. And if there's anything that they feel they need to bring to my attention, they will do that.
You went back to the high level and a concept that I indicated earlier that I do not understand. Would you mind explaining it in the context of how you dealt with it just now?
Did I mention high level now? I don't recall mentioning high level now in my explanation of this, in my response. So I'm trying to understand how to respond to that question in terms of context.
If I misheard, I will withdraw. But my understanding was when the witness started answering me, she said, as I said, I deal with high level. So for me, it's really confusing, but I can leave it at that. The record will bear me out.
Yes, I think we'll look at the transcript. Just the last part that is worrisome to me, Advocate Batohi. These Katomena cases, we all know by now that they involve racketeering, correct?
That is correct.
And in terms of the legislation, racketeering is within the exclusive jurisdiction of the head of the NPA. When you look at Section 2.4 and other provisions.
That's correct.
Now, this matters being within your exclusive jurisdiction. You take over from a former NDPP beginning of February 2019, and you deal with these matters in the manner you did, delegated a number of matters to some advocates on issues that are within your exclusive jurisdiction. I said, this is worrisome to me because no one will account on these matters other than you. Am I correct?
Chairperson, to explain this, I agree that the National Director is accountable.
No one will account on these matters within which you have an exclusive jurisdiction. Am I correct?
Chairperson, if I may be allowed to answer that and explain what I mean by that. Indeed, the NDPP is accountable for his or her decisions. And this is an NDPP's decision to authorize a racketeering matter. But it should not be worrisome that a national director deals with this matter in this way.
No, you cannot answer for me. They do worry me because I've listened to the evidence. I've looked at the legislative framework and provisions. That's why I'm asking you the question that being the head, who assists with these powers exclusively, and matters of this nature arise, who should really account? I do know, and I do take note of the fact that you could have delegated certain powers to some of your advocates because of your busy schedule. But now, because we are dealing with matters within your exclusive jurisdiction, I get worried that you might have failed to do what you ought to have done in terms of the legislation. I may be wrong. That's why I seek your assistance.
And Chairperson, this is what I'm trying to do, is to explain to the chair how these things are done so that it should, in my view, not be a cause for concern. If you look at how national directors deal with these authorizations, in fact, I think it was Advocate Mr. Ngasana's affidavit, where he says that when Advocate Jiba took the decisions that she did in the original authorizations, she relied on reports that were given to her from prosecutors, etc. And that's the correct thing. She absolutely did what is expected of her, even though authorizing is purely a national director's function. She was correct in relying on reports from either Advocate Chauke or the prosecutors in that matter, and not reading the dockets and documents herself. Well, not documents, but the dockets and all the evidence.
It will be helpful. I'm sorry to interpose. Let's not talk about what Advocate Jiba did. She's not before us. Let's talk about you. Because she may well have been here to answer the questions that I'm asking you, but she's not here. And as the head, you are the only one at this point who can assist us to understand how your office functions.
Chairperson, that's what I'm trying to do. I am not answering for Advocate Jiba. What I'm saying is, this is the way national directors deal with these matters. And I said she, in fact, acted appropriately in that matter when she took a decision and relied on reports from those that are her subordinates. That is the way a national director deals with these matters. Advocate Ngasana, likewise, decided not to appeal, and he can speak for himself if he's called. My understanding would be that he would not have looked at all of the dockets and read all of these in detail. And so all I'm saying, Chairperson, is that, and there's sufficient case law on this, that a national director is not expected to read every single docket and all the evidence, and that you can rely on others in your office, even though it relates to a racketeering matter, to give you reports and to make sure that you have the necessary assurance and checks in place to make the right decision. So in this case, Chairperson, there was absolutely nothing wrong with the way in which I managed this matter.
I do note, and I don't want to have this exchange with you, but I do know that you earlier answered that you don't read all dockets. These questions revolve around the email which was directed to you personally. Not talking about a general issue relating to all documentations that are within the space of the NPA. I'm talking about communication involving these serious allegations of witness tampering in matters revolving around racketeering, which is within your exclusive jurisdiction.
Chairperson, I explained as I did, and I can take the matter no further.
Thank you.
So getting back, if I may, Chairperson, to one of...
Before you go back, let's just wait for counsel to take us to where he was,
Chairperson,
because we interrupted him with the question.
Yes.
Chairperson, I had actually been interrupted, with all due respect. I was answering counsel's...
No. I'm saying he can remind us of the question he asked you when we interrupted your answer.
I have the question written down, Chairperson, and I can...
No, he can ask it.
Okay.
Thank you. Advocate Batohi, I think just read what you want to read,
appreciate that.
because you seem to be keen to read something.
No, I'm not keen to do it.
Just read it. I'll move to the next question.
Thank you very much. If I may then. I understood counsel to say...
No, don't read my question. Just read the answer you wanted to give. I have other questions.
I have to answer it in the context of the question. So I want to remind myself as well as the panel. Gosh, so much has happened since then. I'm trying to find where I wrote it down. If you'll bear with me, Chairperson, just for a minute.
Advocate Batohi, my sister reminds me that it's long after tea time. As you are perusing your notes, looking for the question, Advocate Batohi, I don't know whether you'd like us to take a break or you wait for Counsel Batohi to look for the question and answer, or whether would like us to adjourn.
No, Madam Chair, you gave the correct instruction that I not to continue asking the questions. The witness countermanded. So I'm asking the witness, she must read what she wants to read. Now she's wasting time paging through. So if she's found the portion, she must just read it, so we move on. And I will be happy after that has been answered to take the adjournment. But I was happy with your initial direction, but the witness protested. That's fine. But she's now not reading.
Would you please read what you said you wrote?
Yes, I will.
I thought I was guiding.
Chairperson, with all due respect, if I had been allowed to answer the question fully at the time, I would have dealt with the two aspects. But a lot happened after that, and I've written a lot of things down, and I'm trying to go back to find it. So I'm not trying to waste time, Chairperson. I'm really trying to deal with this
It's not
efficiently.
helpful to be argumentative. It does not help any one of us, Advocate Batohi. I tried to assist by guiding, because I also wanted to recap where we ended, and I asked that counsel could recap and take us where he ended when I interposed. And you insisted that you want to read your answer. And that's where we are now. Do you have the answer?
Thank you, Chairperson. If you'll give me a minute.
What is going on?
Chairperson, I will try. Chairperson, if I may, I will try to find it during the break. But what I recall was put to me was that words to the effect that I had, there was no evidence. I had indicated to the DPP that there was no evidence in the racketeering and predicate offenses. I could be mistaken. I need to check my notes carefully. But I want to say that I had indicated to the DPP that there was no evidence on the racketeering matter, and that she was to decide on the predicate offenses in the matter. So I just wanted to clarify that.
So that's the answer you wanted to give.
Well, I'm still going to check and make sure your question was precise, but that is the answer that I wanted to give. Yes.
Thank you.
Counsel, may I just come in here? I know it's tea time. May I or not? Okay.
Advocate Toby, before my sister takes off, you want to follow up?
No, Madam Chair, I think we should take the adjournment. This has not been a productive 5 minutes.
Advocate Batohi. After the chairperson had asked questions, you insisted that you want to read the question. You insisted that you'd like to read the question that Advocate Nkabinde had asked you. And the chairperson engaged you to say, no, but let's give him a chance to recap on that. And in your own word, you said, I have written the question and I'd like to read that question. And now when you are given the opportunity to read the question, now you can't find the question, you have to go through your notes. Is that the case?
Yes.
Thank you, Chair.
Thank you. Let's take a tea adjournment until 12 o'clock. You are still under oath, madam. We'll adjourn. Yes, thank you. Advocate Batohi, you're still under oath.
Noted, Chair.
You may proceed, counsel.
Thank you, Madam Chair. Advocate Batohi, can you just go to the answer you gave before the adjournment? When I put to you that you told the DPP of KZN that the report of Mr. de Kock did not find evidence of the predicate offenses in relation to Major General Boyson. You said that's not what you said. Is that correct?
I'm not sure if I made a full note of your question, but I did find it. And I was trying to write quite fast, but it appears from my note here that what I said to the DPP was that there was no evidence, not just on the racketeering charges, even on the predicate offenses.
Yes.
But I don't know if I mentioned the de Kock report, whether you mentioned the de Kock report when you put that question to me at that
All
time.
right, it doesn't matter, but I just want the substance of it. But what do you quibble with on the question I asked you? What do you disagree with?
What I disagree with is that I would have mentioned that there was no evidence on the predicate offenses as well.
Your letter to the DPP was limited only to the racketeering. Is that your point?
That I would have said that there was no evidence with regard to the racketeering offenses. I'm not sure if I said anything about the predicate offenses.
No, but that's what I'm asking you, because I had put to you that you had said that there was no evidence also on the predicate offenses. Now you disagree with that, but I want to understand, where do you and I disagree? Are you saying you never mentioned anything about the predicate offenses in relation to General Boyson, or you did?
I'm not saying I didn't mention anything about the predicate offenses, because I asked the DPP to look into the dockets and make a decision on the predicate offenses.
Yes. I'm asking you whether you expressed a negative view that there is also no evidence on the predicate offenses in relation to Major General Boyson. Is that correct or not? I mean, why are we...
Can I look at the letter? I don't think I would have.
All
We
right,
can
well,
refer to the letter.
Okay, let's do this. Let me take you to the
That will
letter.
help.
It is at SB4 229.
Yes, I see it.
Then go to SB4 230 at paragraph 4 and look at the 5th line, which starts with, I bring to your attention.
Yes, I see it.
Can you read that?
Well, perhaps I'd like to read the entire paragraph 4.
No, just
to
answer
put it
my
into-
questions, not ask your own questions. Read from, I bring to your attention.
I bring to your attention that the panel also found that there was insufficient evidence against General Boyson in respect of other charges preferred against him. Please take this into account in your evaluation of the evidence against him in respect of those predicate offenses in which he is charged.
Do you accept that you said to them that there was insufficient evidence against General Boyson on the predicate offenses as well?
No, there was insufficient evidence against General Boyson in respect of the other charges preferred against him.
Yes, but
The
those are the
charges-
predicate offenses.
In my view, that is the racketeering charges. And that I was asking her to consider the predicate offenses and make her own decision.
Can I tell you, Advocate Batohi, that your answer is a blatant lie?
Counsel, before that, from the reading of paragraph 4, Advocate Batohi, mention of other charges preferred against him, other charges. Which charges
Yes,
were
I
those?
see that. I do say other charges.
Which charges are those?
Well, he had racketeering charges against him. I'm not sure that there were other charges preferred against him as well. My understanding is that there were only racketeering charges preferred against him. And yes, that's my understanding.
Is other charges in this context not referring to the predicate charges?
Well, Chairperson, I'm trying to understand what I was saying there. I bring to your attention that the panel also found that there is insufficient evidence against General Boyson in respect of the other charges preferred against him. Now, you're correct. I mean, it would appear not to be the racketeering charges, but I'm not aware of other charges preferred against him, except in the context of, I think it's charges 8 to 12 that are mentioned in the indictment.
The opening sentence of paragraph 4 refers to the predicate offenses.
Yes, that is correct.
So, wouldn't other charges within this context not be referring to the predicate offenses?
Yes, Chairperson, that's why I wanted to read the entire, to get the context, the entire paragraph 4. So if one reads the whole thing, then yes, you're correct. It relates to the predicate offenses, which is what I said I asked the DPP to make a decision on.
Thank you, Counsel.
Advocate Batohi, the answer you've just given is a transparent lie. Your letter is clear that paragraph 3 records that you have withdrawn the racketeering charge. Paragraph 4 is about the predicate offenses.
Yes, that's correct. And that is why I wanted to read the entire paragraph so that I get an understanding of the context.
And to show that it is also a transparent lie, you now claim not to be aware that General Boyson was facing charges other than racketeering, when your own affidavit before this panel says that you were aware of it.
I'm aware that he was facing racketeering charges, and there are predicate offenses that relate to the racketeering charge.
Advocate Batohi, please, you are an advocate of the High Court. It is not nice for us to tell you not to lie. We don't enjoy it.
I'm not lying.
You are lying when you claim that you were not aware that General Boyson was facing charges other than racketeering.
I am not lying. I'm saying to you, there are racketeering charges, and in order to prove racketeering, you need to prove other predicate offenses.
No one has asked you that question. We are looking at your letter where you now say you were not aware there were charges other than racketeering in relation to General Boyson.
That is correct. What I'm saying is that he was charged with racketeering and that there were predicate offenses that are elements of racketeering charge. That is my understanding, that he was charged with racketeering only, but that there were predicate offenses that need to be, and which is an element of the racketeering charge.
Advocate Batohi, you know, when I started this cross-examination, I'm going to ask the panel to stop, and I'll go to the transcript. When I started this cross-examination, I asked you whether or not you were aware that Major General Boyson was facing a murder charge, 2 murder charges. You said yes. I asked you whether or not you were aware that General Boyson was facing charges about defeating the ends of justice. And I asked you specifically, separately from racketeering, when we were analyzing the charge sheet. You confirmed all of that. It is the first time now, today, that you give evidence that you were not aware that Major General Boyson faced charges other than racketeering. Very first time. It has never been said before by anyone.
All I'm saying is that there are predicate offenses that are linked to the racketeering charge. And that is why it's so intertwined, these predicate offenses with the racketeering charge. So yes, in order to be charged with racketeering, you need to have committed predicate offenses. And that is why I would have said what I did. But it's in the context of racketeering.
Advocate Batohi, your paragraph 4 is clear that it is different to paragraph 3. Paragraph 3 is about racketeering. Paragraph 4 is about predicate offenses. When you refer there in that sentence, I bring to your attention, you are not talking there about racketeering. Isn't that clear to you?
That's correct. Having read the entire 2 paragraphs, that is correct.
Then why did we waste time of the panel on an exchange like this?
I didn't waste time. If I was allowed to read the context, it would have been clear.
Can we just come back then to where we were before the adjournment? Just to get the summary of what actually is your testimony. Number one, my understanding is that you admit that Mr. Danikas brought the crime of witness tampering to your personal attention together with attachments which were evidence, correct?
Correct?
Yes. Number two, on your version, you did not read the email, correct?
That appears to be the case, yes.
Well, it can't appear to be the case, Advocate Batohi. You were confident with the first answer that it was correct. You are now shifty on the second answer, that it appears so. And you have done this so many times that you never give straight answers.
And the answer for that is because I'm trying to cast my mind back 7 years. And it's not easy to do that. So that is the only reason why I'm answering in this way, because I'm trying to understand what happened at the time.
Yes, the problem with that stance is that there are other facts that you can answer clearly, and there are inconvenient facts where you become shifty.
I got no comment on that.
Number three, the same crime of witness tampering was brought to Advocate Mzinyati, correct?
Yes.
Number four, he read the email because we know that because he responded, correct?
That is so.
But Advocate Mzinyati failed to address the claim of witness tampering or even to respond to it, correct?
That's what appears from the emails that we have.
We know that the same email containing allegations of witness tampering went to the DPP of KZN, Advocate Elaine Zungu, correct?
Yes, that is so.
We know that she too did not address the crime of witness tampering, correct?
That appears to be the case.
Yes. Now, institutionally, yourself, Advocate Mzinyati, and Advocate Elaine Zungu collectively failed to address the allegations of witness tampering, which are a crime, correct?
Yes, that is correct.
Yes. All of you are responsible for defeating the ends of justice.
That's not correct.
You personally acted in breach of your own oath of office.
That's not correct.
Yes. Now, that is what I will argue in the end, that you violated the provisions of the NPA Act because you failed to address a crime brought to your attention. The matter then became a subject of discussion. If you go to page 369,
At 369.
yes, this is the same file, Madam Chair,
Same
that we've
file.
been dealing with.
Is that SB?
No,
Or-
it
or
is just
file
file 3. Yes,
File
I'm told that it's become a little bit difficult to bear. Thank you. Now, if you go to page 369, there is more information that is disclosed by Mr. Danikas to the officials of the NPA. There is Sheriza Ramutha and Nothando Mbisi at the bottom of that email. Who are those people?
They're both advocates in the DPP office, Durban.
But we know that email then comes to the attention of the DPP herself. If you look at the top of 369, or Advocate Elaine Zungu, correct?
That is correct.
Yes. And how it comes to her attention is because Advocate Sheriza Ramutha has prepared a draft response and is showing the DPP the contents of the draft response, correct?
I'm just looking at the emails.
Well, it says, see my response to Mr. Danikas.
Yeah, which I'm assuming she's referring to the email below. I'm not sure if there's a draft attached.
Well, we know the letter that was sent, which we assumed was the draft, is the letter we looked at last week. At page 366. That's the one with enquiries S. Ramutha.
Yes, I see that.
So that's what I'm saying is the draft that was being circulated at the time internally.
I'm not seeing that the draft was circulated. If I can be pointed to that, I can respond.
Well, it says, see my response to Mr. Danikas, and here's to me attached.
Ah, yes, I see that.
So there are clearly attachments there.
That is correct.
Yes, all right. All right. What I want to refer you to for now is the email from Advocate Sheriza Ramutha on the 21st of November, 2019. And what she is saying to her colleagues, Mr. Nel, Mr. Sankar, Ms. Dlamini, is please see the trailing email from Mr. Danikas re the Ketomano matter. Does this relate to any matter that you have dealt with in this project? It appears that she is not even aware of the involvement of Mr. Danikas in the case, correct?
It appears to be so.
Yes. And then the draft that she is proposing, if not, I am simply going to write to him and inform him to send his evidence information to SAPS, as he is under the impression that we are investigating the Ketomano unit. So here it appears also that she is under the impression that the Ketomano unit is not even being investigated or considered by the NPA.
She's under the impression that investigating is in inverted commas, that the NPA is not investigating it. That's my understanding.
Yes, correct. But I don't know what is the disagreement there. Because I'm saying exactly what you're saying, because it's clear from the email. And then look at what Mr. Danikas is bringing to their attention, which is at the bottom of the page. It says, good morning again, Ms. Ramutha. I am attaching a short audio file and a video capture frame. This is an extract from previous security video file recorded in my old electronics store in Smith Street, Durban on the 21st of January, 2016. In particular, I refer to the video clip I previously provided in my statement to the NPA in 2016 in Greece at the SA Embassy. Attached photo frame, Boysen on his knees with white t-shirt and shorts far right. Boysen proudly and graphically describing me and my wife, how he and his members, while on duty and driving a Lumina, shot at, for their entertainment, innocent civilians at a taxi full of Africans because the driver will not let him pass. There are 3 incidences described by Boysen within the original video recording. Then it continues. I have attached only the one audio part that, in my view, is clear and describes how Boysen and Ketumana members shot at a prostitute from their car. The details are clear on the audio. I have used some sound filters to clear the background music, a demonstration as to how an expert sound engineer can further clear the remaining sound recording of this video clip. Did anyone from the investigating team ever submit this crucial video recording to a forensic sound expert in order to authenticate and clear the audio? I believe that this part of the ignored so far evidence is crucial to your pending investigation, as it paints a criminally and a graphic picture of those racist police members' mentality and how they operated with a total disregard to the law, as well as a racist behavior towards Africans. Out of the courtesy and prior to share this part of the sound clip, as well as relative video clip to the media, I am forwarding to you for further investigation. As I am an active member of the 2 international NGOs for human rights, I have dedicated my life to uncover the hidden truth regarding the Ketumana unit. Now, the substance of this is this. There is a video and an audio that is circulated to the attention of the DPP, which has already been given to you by virtue of the email we looked at on the 8th of August, 2019. But this one contains even more evidence of Mr. Boysen himself confessing to the commission of a crime. Can you see that?
It appears to be so.
Yes. Now, the man is sending a video to the DPP's office. The response you get internally is that everyone in the DPP's office is confused about his status and is confused about the status of the investigation. That is what Ms. Advocate Ramantha appears to be. Then it continues. On the script, best played with Windows Media or VLC player and with the Trebles Law, Boysen can be heard saying to myself and my wife, did I tell you about the night we shot the prostitute? We stopped, opened the door like this. She walks to me like that, short dress with an A like that. We shot across the road, dish. Vipir van Tonder handles this thing very well, well. Now she is stupid. While she is looking at him, douche. And we leave. We come back. Genuine, there is a table inside. And there is under the table, looking like what's going on outside. End of the script. Now, this is, according to Mr. Danikas, all recorded in the video where Mr. Boysen confesses to having shot an innocent woman. And might I remind you, these documents we're looking at now were discovered to us over the weekend by Ms. Karen van Rensburg. These are NPA's own documents. And we don't criticize her, we actually thank her for doing this.
That's correct.
Yes. Then it says, the above are clearly heard on the short part of the sound clip I have attached within as part of my video clip that I have submitted back in 2016 and having been ignored by the NPA so far. She says, I've given you these videos, you've ignored them. so far. Then it continues, should your investigating officers find my original evidence that I have submitted previously, the video can be processed and analyzed further. My wife is willing to give also a supporting statement via an MLA request in Greece. I have maintained since the beginning of the NPA criminal investigation of the Cato Manor unit that my evidence introduced could be linked to human rights violations, racist behavior, as well as criminal activities committed by Cato Manor members and Boysen himself from 2000 until 2008 that I served with the unit. Since 2013, a systematically fake news propaganda against my credibility was launched on the media by the accused to discredit me as a witness, as well as interfere with the investigation to the unit and himself. Then he makes an undertaking. As I'm an ex-police reservist myself, with 10 years experience in CSI, I can assist further with your investigation and those criminal acts by Cato Manor members and Boysen himself. Now, I assume that none of this was brought to your attention because we don't see your name, but what we can see for sure is that it was brought to the DPP of KZN.
That's correct.
Yes. We can also see that we played videos on Friday where we see the same pattern. Videos are brought to your personal attention, nothing happens. Same videos with more are brought to the attention of the DPP, nothing happens. Do you have any comment on that? I mean, why are witnesses who possess original evidence reporting crimes to your offices? Nothing happens.
What I do want to say is that this does concern me, what you've read out. It doesn't look good. And for any police officer to conduct him or herself in this way is not acceptable at all. So, and as I've said previously, I mean, Boysen and others could have been, no one's saying that they're angels. And from this, it doesn't appear to be, it's seriously concerning, as I said. Again, I say, when we prefer charges as prosecutors, we must ensure we have evidence, no matter how a person could be a criminal, we cannot charge anyone without the evidence. And that is all we're saying, is that when we do charge people, we must have the evidence. This, of course, is very concerning.
But what of the members of the NDP themselves, let alone the police officers? What about the conduct of your officials themselves?
Chairperson, this is concerning, and I will have to look at this and reach out to the DPP to understand exactly what happened in this matter.
This touches on illegality, doesn't it?
Chairperson, yes.
On the part of NPA's officials' consent.
I'm not sure on the part of NPA officials. I was referring to the conduct of Boysen as set out by Danikas. But on the part of the NPA members, I have to hear from them first to understand exactly what happened in this matter before I say that they acted illegally.
Yes, I hear that. But I said, put aside Major General Boysen's let's look at the conduct of the NPA advocates to whom this correspondence was signed and who, on your own version, did not react to this conduct. The witness tampering allegations that was complained of, and nobody did anything about it. Hence, I say the illegality on the part of your own officials who did not act upon the complaint of witness tampering to them. And your answer was that, yes, it's a matter of concern that police officers could behave that way. And I say to you, let alone the conduct of the police officers, what of the conduct of NPA itself, given the context of these emails?
Chairperson, as I said, I need to speak to the DPP, write to her to get an explanation from her about this before I can make any further comment on their conduct.
Yes, but you are the head. We have evidence before us that is not disputed. There was this communication, and Mr. Danica still says, I was prepared. I communicated in 2016 to your office. I continue to communicate about this, for the lack of a better word for now, illegality, the tampering, the intimidations that you talked about, the abuses, and nothing happens. And the question is, as counsel has just put it to you, and you say, it is of concern to me that police officers could behave this way. So if you can make such a judgment about police officers, so you can make a judgment about your own officials who are implicated in these emails. And my question is, if it was of concern to you, or is of concern to you now, that these officers behave this way, what of your own officials who dealt with these matters, or ought to have dealt with them?
Chairperson, I was responding to whether it's illegal on their part, their conduct. In that regard, if I may say, I cannot say that it's illegal, but certainly I need to, it doesn't look good, and I need to understand exactly what happened and why it was dealt with in this manner.
Is it not of concern to you?
It is of concern to me, Chairperson.
That's the point. Because it is easy to say what the officers, the police officers did is of concern to you. But you should even be more concerned about your own advocates.
Chairperson,
To whom the complaint, I beg your pardon, let me finish. To whom the complaints were made. It's just as simple as that. Does it not concern you as the head of the NPA that your own subordinates or advocates behaved in this fashion?
it does, Chairperson, and as I said, I need to get a report from the DPP about exactly what happened in this matter.
It is important that it is of concern to you. What
That
you're
is
going
correct.
to do hereafter is neither here or there.
Noted, Chairperson.
Thank you.
As a follow-up, Advocate Batohi, these emails emanate from November 2019. And not only these emails, but even the evidence that we saw on Friday, the videos that we saw on Friday, you gave the same response, that it is of concern and you are going to request an explanation from the DPP KZN. aren't we past the stage of requesting explanation and we are at the stage of action, given that this, I'm not talking about occurrences, I'm talking about this information was brought, well, with others, for example, Meridi has, it was brought to your office's attention. Danika's email was brought to your office's attention, and you were copied in that email. But in all these instances, nothing happened. Are we still, realistically speaking, are we still at a stage where you can make a promise that you're going to do something, or we are at a stage where somebody have to act? Especially given that when you started testifying, you said victims of crime are very important and they are your clients, and you must always make sure that the victims of crime get justice. Now, here we are. We're talking about emails that were sent 2019. We're talking about events that took place before then. Where is the justice there? Is the mere saying that I will do something giving comfort to the victims?
Chairperson, in these circumstances, the first step I have to take is to seek a report from the DPP to understand exactly what happened here. And then the next steps is to decide, depending on what's in that report, if further action is warranted. But it is in fact action to first ask the DPP for a report in this matter.
In other words, you are still going to ask for an opinion whether action is warranted in the face of what we are looking at now. But one would understand before this sitting, because you said you didn't read everything, or you didn't read, but now it's in your face, it's in front of you. Are you still going to request a report or an opinion on whether anything went wrong and something should be done, or are you going to act on what is in front of you now?
I have to first ask the DPP to give me an explanation for how and why this was handled in this way. That will be my first step. I have to do that. I have to hear what she's got to say about this and then decide on any necessary steps after that. It's not an opinion, but her explanation of how this matter was dealt with in the office.
For our purpose here, of what relevance is that step? Your decision to take the steps that you have mentioned hereafter, of what relevance is that step for our purpose now, as an inquiry?
Chairperson, I've been asked about it, and that's why I'm saying what I'll do.
Thank you, Madam Chair. Advocate Batohi, you know, the answers you've been giving to Advocate Baloimer are interesting to me because they show you up as somebody who is fundamentally inconsistent in their leadership. On the 6th of March, 2019, you were already prepared to take disciplinary steps against Advocate Mayema without having satisfied yourself about anything. Today, there is Advocate Elaine Zungu, there is Advocate Mzinyati, there is in fact even yourself, all of you complicit in defeating the ends of justice. But you are not prepared to commit yourself to initiating disciplinary steps at all.
If I may comment on that. Chairperson, in order to make decisions to take disciplinary steps in any matter, there is a process that has to be followed. Even in the case of Advocate Maema and others, as I mentioned, I had not taken any decision to institute any disciplinary steps against them, but to ensure that there's a process, and that process itself will determine whether disciplinary steps are necessary. As I also mentioned, I did not take the decision in that matter to institute any disciplinary proceedings. There's a separate process in the NPA that I'm not involved in that results in somebody else deciding that issue. And so here, likewise, I must engage in a process. And so it's totally consistent with how I operate.
Advocate Batohi, you are the one who introduced the word discipline in the 6th March 2019 meeting. Happily, when it came to Advocate Maema. Today, it is a big problem because it is a different staff of the NPA that is involved. This is why I am accusing you of being a fundamentally inconsistent leader.
That is not correct, because even if disciplinary steps are required in this particular matter, there is a process that must be followed. So there's nothing inconsistent about it. I have to make sure that the process is properly followed.
Can you tell me about your own conduct of failing to read an email which reports a crime? Is that consistent with your oath of office?
I generally read, as I said, emails that are addressed to me, I read them. Where a deputy is, it's also written to a deputy in my office. Then I often leave it to them to deal with the matter. So it's perfectly consistent with my oath of office.
Your evidence on Friday that you expected Advocate Mzinyati to bring it to your attention, and the revelations this morning that it was in fact brought to your attention, is that also consistent with your oath of office?
It is consistent with my oath of office to make sure that matters that are brought to my attention are dealt with within the office.
No, I'm asking about your attempt to mislead the panel by blaming unfairly Advocate Mzinyati for an oversight of not bringing it to your attention, when the truth is it was brought to your attention. That attempt to mislead the panel, is that consistent with your oath of office?
It wasn't an attempt to mislead. I mean, we're dealing with matters 7 years ago. I don't even know if I opened that email, if I saw it. I've got no idea. I'm trying to recollect what happened to me, what happened at the time. So there's absolutely no intention to mislead. As evidence is presented, you know, it gives us a clearer picture of what happened. But I'm trying to just cast my mind back to think about what might have happened or could have happened. And that puts me in a very difficult position. So I'm not trying to mislead at all.
Thank you. Now, there is a further set of documents that we also got from Advocate van Rensburg, helpfully. They start at 373 to 394. Now, what is interesting in those documents is that we have the original response from Advocate Sankar on the prosecution of Warrant Officer Padayache for having killed KwaZulu. That original explanation is at page 389 to 391. Can you see that?
I do.
Yes. Now, I went through that to look for an explanation why the ballistic report of Captain Mangena was not introduced. There is not a single reference to Captain Mangena there. Do you accept that there's no reference to Captain Mangena?
Yes, that's correct.
Yes. Now, the other allegation that was made by Mary de Haas was that Mr. Sankar, Advocate Sankar, attempted to force the family to settle for an inquest instead of a trial. There is not any response to that allegation.
That's correct.
Yes. Now, these are the two most critical elements which gave rise to the accusation that there was an attempt to suppress evidence, quite apart from the fact that the report of Dr. Naidu and Mr. Stale is grossly misrepresented. And it seems that what happened is that the misrepresentations that were made by Advocate Sankar filtered through to Advocate Elaine Zungu and ultimately filtered through to yourself. Can I ask you if you ever read these reports from Advocate Sankar that went to Advocate Zungu?
I can't recall.
Well, it seems to me, considering the pattern of your evidence, is that you most likely did not read them.
I can't agree with that. I don't know if I read them.
Well, I'm giving you a chance to explain whether you read them or not. You say you have no recollection.
That is correct.
Yes. Because if you had read them, you would have asked yourself the immediate question, why have you not responded to the accusation by Mary de Haas that you attempted to force the family to settle for an inquest instead of a trial? Because it's such a glaring omission.
I can't comment on that. I don't know.
I don't understand what you mean. You had the statement by Ms. de Haas. You have a draft response by Advocate Elaine Zungu. The draft response is deficient because it does not address the misconduct of the prosecutor in forcing a family, a poor family that is illiterate, to settle for an inquest. It is the most obvious thing to ask them. Your conduct, Mr. Prosecutor, is impugned because they're saying that you are trying to direct the family wrongly. What do you mean you can't comment on it? The only way you could have come to the conclusion you did to sign this letter, which is misleading, is because you did not read the original response by the prosecutor.
I really don't know if that was before me at the time. I can't comment on that at all, beyond this.
Because if you read it, and despite having read it, you came to this letter that you wrote, then there is a real problem of your ethics.
There's nothing unethical about this at all. As I said, I depended on the report of the DPP. Following the events that unfolded in this inquiry, I have in fact asked her several questions about the way in which this matter was handled, and I hope to get that report on my desk very soon.
No, I think you are not answering what I am talking to you. I am saying to you, the most favorable interpretation to you is that you did not read the report of the prosecutor. You are resisting that interpretation.
All I'm saying is I can't recall what happened at the time.
Yes. Because if you read it, you would have seen that it is misleading.
I'm not sure about that. It may perhaps have some omissions. It does, in fact, have omissions, but I'm not sure that it's misleading.
I see. Again, Advocate Batohi, this stack of documents, they are now a fuller account of what happened than the pieces we had on Friday, which we got from third parties. But this stack from 373 to 394 came from your office, from Ms. van Rensburg. Do you have any comment on that?
That's correct. We've got nothing to hide.
Well, you had nothing to hide until we asked for them.
When things became relevant, we are willingly providing whatever we need to. We're not trying to hide anything.
Anybody suggesting that you were hiding anything? Why don't you just answer the question?
That was the impression I got, Chairperson. Maybe an incorrect one.
Just answer the question.
Yes. Yes. In fact, to that impression, Advocate Batohi, the only point I was making is that these are not our documents. They are NPA's documents. And we got them from one of your colleagues, Ms. van Rensburg.
That's correct.
Yes. Madam Chair, I'm going to start a totally new topic. I'm done with the disclosures we got over the weekend. I'm in your hands to whether to do it now or after lunch. The time is 12:59.
Yes, Council, before you proceed to the next topic, I'd like to ask some questions regarding the delegations of powers in your office. You being the head of administration in the office, you will be well conversant with the issues of governance and how you have pegged your order of delegations within the NPA. Is that correct?
Well, I'm the head of the office, and certainly I think we can safely assume that I will have those matters must be done properly in terms of delegations that are given to DPPs. So my answer to that is yes.
Yeah, my questions are not going to be confined only to delegations to the DPPs. It is unfortunate that every time I ask questions, there's maybe just one or two that would have been answered as questions that were asked by me, but most of the time you don't. But that is something that will be taken care of in due course. Please, when I ask a question, I understand the question that I ask. If you don't understand it, it would be helpful to ask me to repeat the question rather than to answer and then I have to go back to correcting the question or reiterating the question that I have asked. And the question that I have asked is that as the head, like you call yourself the head of the institution, which is correct, as the head of the institution, you are actually in charge of governance and you are actually conversant with the governance issues with specific reference to delegation of powers. And I said in their pecking order. Once I say pecking order, you can see that it may apply to several other positions.
This is a difficult one because, yes, I am the head of the institution. I do have a lot of, there are other sections that deal specifically with various types of delegations that I may not be completely au fait with. So that's, so I'm not sure if I'm answering your question properly, but I may not be aware of all the issues relating to the delegations in the NPA.
Let us talk firstly about the delegation of powers between yourself and your deputies. Are all the delegation of powers by yourself to your deputies in writing?
There are some that are in writing. Others are delegated authority by virtue of the area or the business unit that they run.
As the overall head of the institution, or rather, let me not go there. Let me still stick with this issue of the deputies. Now, your deputies, you delegate certain functions to them. Certain functions, yes. And when you do that in writing? Do you give written delegations of authorities or not?
There are some that are in writing.
Now, arising from your answer that you expected Advocate Mzinyati to attend to the email that had been sent from Mr. Danikas, is it one of the matters that fall under the written delegations of powers that you have? Just in a broad spectrum,
yes.
Not specifics, because delegations of powers are generally done on a broader spectrum, and then specifics just fit into that. So, does it fall within that spectrum?
If my memory serves me correct, there is a specific written delegation for the deputy to deal with representations. So it could potentially fall under that, or it could fall under the deputy's power and authority with regard to the business unit that they head, where they will then deal with whatever aspect of it needs to be dealt with.
Know or you do not know as to whether it falls within the regions that you would have given or not?
I think
you know or you don't?
I don't think it falls under the representations. I think this is a communication. It's not actually a representation. So I don't think it would fall under that written delegation.
Do you know or do you not know?
Well, just
because
looking...
I don't think it's not good enough. It
Sure.
does not indicate as to whether you know or you don't know.
Understood.
Yes.
Looking at this email, it's not a representation. It's a communication. So it wouldn't fall under that delegation.
Do your deputies have the powers to also delegate delegated functions?
No, they have teams assisting them.
So in this case, if this matter falls within the scope that you would have delegated, Mr. Mzinyati would not be empowered to delegate it further. It means the buck would stop with him.
He cannot delegate it further, that's correct.
And that means that the buck would stop with him in terms of delegations.
That's correct.
But ultimately, the buck would stop with you as the officer that is statutorily provided for to deal with the matters of the office.
That's correct.
Right. Now, going to the directors of public prosecutions, do they have the delegations or the powers to delegate their functions to the junior staff?
They get direct power from the Act, and they can delegate it to those within their office.
Yes. And do you know how far they can go with the delegations, or it would be just immediate delegation from the officer to the next below him or her in office?
A DPP issues delegations to prosecute to all prosecutors in their division.
Okay.
So you get a direct delegation from the DPP to prosecute in his or her division.
Now, just going back to this matter in particular, the matter of Boyson's, which is linked to the Danika's statements and information that was sent to you. In your evidence, when you testified, you stated that the Boyson's matter you regarded as serious and needing urgent attention because it is one of the matters that had actually dented the image of the NPA.
I can't recall precisely what I said at the time, but I certainly did say that it was something that needed urgent attention and that it had impacted on the image of the NPA. I don't know what exact words I would have used at that time.
Yes,
but
at the time, the words that you used was that it is one of the matters that had wrecked the image of the NPA. I think the record will speak for itself.
Okay.
You agree?
Well,
it's something to that effect. Just
yes.
in case you say I can't be precise.
It's something to that effect, that the credibility of the NPA had affected it.
And that actually motivated you to approach DPP and others to constitute a panel in June, or rather in April, I think, for them to look at the matters of racketeering, amongst others, against General Boyson.
As I mentioned, the reason why I constituted the panel was to get an an opinion from experienced staff members on this matter so that I could decide what approach we should take in the litigation that was pending at the time.
Yes.
So that was the reason why I got the panel together.
Yeah, the question that I'm putting to you is that you constituted an appeal, a panel, which would, amongst others, look at the racketeerings against the General Boyson's team, Katomena team, let's put it that way.
So I'm not sure what you mean by amongst others, because I think my memorandum to the team sets out what the purpose of the team was. And we can look at that to just refresh our memories. But my understanding is that they were to look into the authorization of racketeering charges in this matter.
Now, that was way back in around April or so. Later, in August now, you get correspondence. It reaches your desk. Correspondence that is lamenting the conduct of the Katomena group. And as you correctly say, this was it's an important matter. It's a high-profile case that needed your attention. You get that information and you decide not to read the email.
It's really not a question of deciding not to read the email. As I said, I couldn't even recall that I got the email. But of course, we have proof that it was sent to my inbox. I cannot recall what the position was at the time, whether I even saw it. I do read my emails. It's important to me that I do, except in circumstances, as I said, where a deputy is copied in and it falls within his or her specific area. Then, of course, I leave very experienced staff members to deal with it. In this case, I cannot recall exactly what happened.
Yeah, to be honest, I'm tired of telling you to answer us questions. So I will just proceed. I will proceed. Thank you. Thank you. I beg your pardon. I will just proceed to ask whether you answer the asked questions or not. The record will speak for itself. Now, notwithstanding the fact that already when you took office, you had, based on what was in the public domain, formed a view that this is a case that has wrecked or rather the handling of the case, which has wrecked the reputation of the NPA. Now, bearing in mind that you had that view, and this correspondence is sent to you in August, while you are still looking for or looking to get an idea of what this case is all about, then you don't read the email. You are not in the lookout for all the emails so that you make sure that nothing escapes you or your attention. I say based on that information or regard being had to that information, you nevertheless do not make it your business to ensure that in order to get things right in this place that has problems, this place that is tainted, one of the safety mechanisms would be for me to read every email that comes my way.
My response to that can only be what I've said. And that is, I cannot even recall receiving this, but senior deputies, are expected to do what their job description is. And I reasonably can expect that the deputies will deal with matters in the manner that it should be. I honestly cannot recall what exactly happened with regard to this matter.
Would you say that the senior deputy Mzinyati failed to exercise her powers in the manner that he ought to?
I can't.
In compliance, just listen. In compliance with the Constitution, the NPA Act, and his oath of office.
I can't say that because he forwarded it to the DPP to get a response.
Thank you.
Advocate Batohi, we will adjourn at 1:30. Given that
Yes.
we had lunch, breakfast a bit earlier, but we have 10 minutes to wrap up, I suppose.
Yeah.
But before you proceed, Let me clarify one or two aspects with regard to the file 3, the additional documents that were made available to us this morning, page 385 and 386, up to 387. Am I correct that this is the correspondence to Advocate Nzinyati, who was acting Deputy National Director of Public Prosecution by the DPP KZN, Advocate Harrison, who has been referred to Advocate Zungu? Is Harrison the same person as Advocate Zungu?
That's correct, Chairperson.
Thank you. Now, this correspondence is dated 20 January 2025. And it seeks to deal with representations that were made by Madam De Haas. Correct?
That is correct, Chairperson.
And the fundamental issue that was identified after the pre-trial conference, apparently in relation to this matter, was the issue regarding whether the accused was armed with a firearm when he was shot at by the accused. If I'm correct, this first accused refers to the young boy's Kwasi, who was shot at whilst lying on the couch at home. Am I correct?
Chairperson, I'm not sure where it's referred to him as the accused, but
If you read, if you read the last paragraph, middle line, page 385, after a pre-trial conference, maybe it will be helpful to read the entire. Ms. De Haas,
sorry, which page, Chairperson?
385
yes.
of the bundle that was made available to us this morning. You
And
see
there.
that?
Mhm.
Ms. De Haas will always complain and question prosecutors' prosecutorial decisions and or prosecutorial strategies used during a trial. After a pre-trial conference, it was agreed that the issue in question was the accused armed with a firearm when he was shot at by the accused? That's what I was reading. Now, the first accused there, does it refer to the young boy, Kwasi, who was shot at whilst lying on the couch at home?
It should be the deceased, Chairperson. It does appear to be referring to him.
Yes. And the second accused will be referring to the police official who is alleged to have shot at him whilst lying on the couch at home?
Correct, Chairperson.
This having been a fundamental issue to ascertain, when you look at the next page, 386, mention is made of witnesses 1, 2, and 3.
That's correct.
And mention is also made what was noted by Advocate Sankar.
That is so.
Let me just quickly read that. He noted that he had consulted with both these witnesses, that is, witness 2, Kobos Stale, and witness 3, Dr. Naidu, who both conceded that they could not ever indicate whether the deceased was carrying a firearm at the time of the incident. That all they could say was that they suspect, in parentheses, in quotation marks rather, he was not carrying same and therefore they were uncertain of the issue. Remember what the issue is, which I read it in earlier? The next line in the next paragraph of page 386. So right, Advocate Harrison, Advocate Zungu, the decision not to call these witnesses, that is Mr. Stale or Dr. Naidu, was that after a thorough consultation with the two witnesses. Now, this letter having been written in 2025, January 2025, we know already from what was revealed to us last week, and having seen the videotape being played here, that subsequent to the shooting, there was a ballistic report by expert Mangena. You remember?
I do.
Which was far earlier, that is before January 2025, correct?
That's correct, Chairperson.
Why is it that your officials, Advocate Zungu, the DPP KZN, makes no mention whatsoever of the ballistic report of Captain Mangena? You know?
I don't, Chairperson, but I have asked her that question just after all of this emerged.
You said you know.
I don't.
You don't.
Yes.
Is it not strange that a DPP seized with a matter on such a fundamental issue decides not to have regard to a ballistic report that tells them about the positioning of the firearm?
Chairperson, it is very concerning that the prosecutor in this case did not mention it in the report to the DPP, which is what she based her response to Advocate Mzanyati on. And I have asked her the specific questions now that all of this has come to light, because it is very concerning that this ballistic report of Captain Mangena is not mentioned anywhere.
We don't know what you asked her. It's not before us. But as a DPP who praises his colleagues and concludes as she did, decides not to have regard to such an important piece of evidence, what should we make of that? Particularly when Advocate Sankara, who was seized with the matter, made certain observations, having consulted with these witnesses and having spoken about what appears to have been their positioning of the firearm in issue.
Chairperson, I don't know whether the DPP was even aware of the existence of the report of Captain Mangena at the time.
Am I correct, though, that the docket would have contained a ballistic report?
That is correct, Chairperson. It should have.
If so, the DPP ought to have had regard to the contents of the docket, correct?
The DPP Chairperson, I'm not sure whether she had regard to the contents or whether she relied on the report of the prosecutor concerned.
No, I'm not asking that. I'm asking, given this scenario that I've set out to you, the DPP ought to have had regard to the contents of the dockets, which, as you say, would have contained or included a ballistic report?
Chairperson, it is not unusual for DPPs to rely on reports that they get from prosecutors.
No, I'm asking a different question. Advocate Batohi, you have just answered that the ballistic report would have been included in the docket. And remember, we have that case number. Esikawenik has 03/04/2010 that we spoke about last week. And that's the very case in respect of which Captain Mangena reported after visiting the scene. We have the ballistic report, there's no issue about that. The point is, if the docket included, not even if, when the docket concluded the ballistic report, as we have just answered, shouldn't the DPP have had regard to that ballistic report?
If the DPP looked at the docket, she would certainly have seen it.
Your answer might necessitate us hearing from the DPP. But I thought it's a standard thing. As the head, you expect your advocates to look into those dockets that are before him and the contents thereof.
Chairperson, just like...
Don't answer for the DPP. He may have to answer for herself or himself.
Chairperson, I'm not answering for her. I'm trying to explain what the practice is.
No, but you say if she read. But I'm asking you, as the head of the NDP, that when the DPP is seized with a matter such as this one, and a docket is in front of her or him, shouldn't a ballistic report contained in that docket be taken into consideration when the decision is made, particularly when the very issue, fundamental issues, concerns matters that are covered in the ballistic report? What Zungu ought to have done or could not have done may not be relevant for now. He may or he may have to answer for himself or herself. But I'm asking you now as the head, your officials, your advocate, your DPP is given a docket. And this docket contains a ballistic report. Ought he or she not have had regard to the contents of that ballistic report?
Chairperson, I am trying to answer for the DPP. I do not know whether she in fact had the docket in front of her at the time. So it becomes very difficult for me to try to answer when I don't know whether the docket was in fact before her at the time.
Yes, but generally speaking, let's assume that it was before her. Let's work on the premise that the docket was before her or him. Can't even remember. It's a
her.
lady. Advocate Harrison Zungu.
It's Harrison now, yes.
It's Harrison now. Elia Zungu.
That's correct.
Thank you, madam. Let's work on the premise that she had a docket because she refers to it. If you look at the headline, she refers to that very same docket, the case number. Obviously, that is a document that is before her. And if that docket was presented to her containing a ballistic report, she ought to have had regard to it, even apart from what the witnesses were saying, correct?
Yes, Chairperson, on the assumption that she had it.
No. I've just said to you, let's work on the premise that she had the docket.
Yes, I thought you used the word assumption, so my apologies for that. If we work on that premise, then yes, she would have seen it.
Just a small follow-up question, Advocate Batohi. You are the head of the NPA. That is a given. And all the prosecutors in South Africa are under your command and your leadership. Am I correct?
Ultimately, yes, they are.
There are certain standards and work ethics that are expected of prosecutors, and you sit in a position where you are the enforcer of such standards. Am I correct?
That is correct.
Part of, or one of the issues that one would expect to be an ethical issue or an ethical standard that should be practiced by prosecutors is for them to read the dockets and apply their minds before they take a decision whether to prosecute or not. And I'm basing this question from your earlier testimony that you kept on telling us about the independence of the prosecutors to prosecute without fear or favor. So I'm saying one of the ethical standards that should be enforced by you as the national head of the NPA is to make sure that they read and consider and apply their minds into every document that they receive that has to do with prosecution. Am I correct?
Insofar as the prosecutor taking the decision is concerned, you are absolutely correct.
And where wrong decisions or no decisions are taken, you have a mechanism to enforce or to deal with such situations. Am I correct?
That's correct.
Now, given the exchange that you've just had with Justice Nkabinde in relation to Advocate Harrison, where obviously, I mean, I will say obviously because we now have the full set of facts in front of us, where obviously she ignored evidence before her and gave a report where she said she could not find any wrongdoing and thus she's closing her file. When do you suppose, as the head of NPA, to re-look into this, or maybe I'm asking a wrong question because you have already testified that you don't read.
I didn't testify that I don't read.
Weren't you suppose, given that there was a lot of prima facie evidence that could trigger a prosecution, and then your DPP says to you, I'm now closing the file, doesn't that trigger something in you as the head of the institution? Or trigger a curiosity to want to look at this particular file, where there are a number of complaints accompanied by video evidence and pictures?
If I may answer. So the first thing, it has definitely, to use your words, well, I'm not sure if they're precisely your words, but it's not just my curiosity. It's raised my concern about how this matter was dealt with. And I have asked for an explanation from the DPP. That's the first part. But the second part of your question states that Advocate Harrison obviously ignored evidence before her. Now, it relates to the exchange that I had with the chairperson, in that I don't know that Advocate Harrison looked or had the docket in front of her. So I cannot say that she obviously ignored evidence in front of her. But certainly what transpired with regard to all of the ballistics reports in this matter is something that I am concerned about, and I have asked the DPP to look into this. And in fact, I did say to her just yesterday, I'd like you to read the docket and let me know. Let me have your report after that. So that is the position with
So
this
you
matter.
discussed the matter with the DPP, who may be a potential witness.
Chairperson,
No, I'm asking, you discussed this matter under consideration with the DPP, who may be a potential witness.
Chairperson, I didn't know that she's a potential witness. I mean, if that's the case, then any member of the NPA can be a potential witness. If I'm being told that I
Don't
should...
anticipate my question, please. Mine is just very simple. So you discussed this matter under consideration with the DPP KZN, who may be a potential witness.
I did discuss it with her.
And last week, mention was made about what she did, Advocate Zungu Harrison.
Her name has come up in these proceedings, Chairperson.
Not once, several times last week during cross-examination.
Her name has come up, indeed.
But you decided to go and discuss these matters with her?
I decided to ask her for a report about these matters, which is what I've done.
You did talk to her?
I did speak to her.
Thank you. Thank you.
Advocate Batohi, on Friday, when we adjourned, the chair reminded you that you are still under oath and asked you not to discuss this matter with anyone. Do you still remember?
Chairperson, anyone, I can't recall what exactly the chairperson said, but I do know that I should not discuss this matter with people like, for example, Advocate Riley. I was specifically said I should not speak to her about it, which I didn't. In this particular case, I mean, I didn't intend to contravene any rule in this hearing about consulting with potential witnesses whilst I'm under cross-examination. Given what has happened in this matter, in fact, it's like a double-edged sword, because if I didn't ask her for a report, then I could have been accused of not being concerned about this matter. So it puts me in a very difficult position as the NDPP about when to ask for reports and when not to. This, for me, is a serious matter, and I asked her for a report.
Acceded that you had a discussion with Advocate Harrison, despite the fact that you are still on the witness box, and you warned you last week. You could have communicated to her through your officials. Advocate van Rensburg, for instance, could have written to request for that report. Why did you have to talk to her?
Chairperson, I will do this in future. I won't speak to any of the NPA staff members until I'm finished cross-examination. I honestly did not think that there was anything wrong with me asking her directly for a report in this matter.
Advocate Batohi, you are an advocate of the High Court. You know the rules. Besides, I cautioned you last Friday when we adjourned, didn't I? I
You
said
did.
you are still under oath and you will not discuss matters with any witness. It has been alerted by the investigating, the evidence leading team when they said they may have to consult with somebody. And this matter arose from there. Then when we adjourned, I cautioned you. But you are telling us today that yesterday you had a discussion with Advocate Harrison, who has been mentioned many times with regard to what is before us. And you can't say that you don't know. Please, you are an advocate, you are not a layperson.
I accept that. May I respond, Chairperson? I didn't intend to in any way influence her with regard to this matter. All I did was trying to get an understanding of what happened to in fact assist this inquiry. But in future, I will make sure that I communicate with staff members through other NPA colleagues that can do it.
The fact is that you ought not and shouldn't have even spoken to her. That's the point that I'm making.
Chairperson, I really did not think I was doing anything wrong by asking for a report.
Toby,
Yes, Madam Chair.
I think we should pause for a lunch break. We propose to adjourn now for 45 minutes, I think. Let me just confer with my colleagues. Yes, thank you. We will take a lunch break for 45 minutes, meaning we will reconvene at 2:30. We will adjourn. Remember, you are still under oath, madam. Good afternoon, everyone. Good afternoon, Advocate Chauke. Advocate Traitobi.
Yes, Madam Chair. I think the best will be to ask my learned colleague, who is leading the evidence, to tell us where is the witness, because the witness does not appear to have returned from lunch.
Well, I asked you because when we adjourned, you were still cross-examining the witness. And I see Advocate Batohi is not here. Advocate Mutlamanyani?
Thank you, Madam Chair. As evidence leaders, we received a message from the NPA team that Advocate Batohi would like to be excused from these proceedings to go and seek legal counsel. As indicated in chambers, according to Advocate Hali SC, he knew that she was already gone, and he indicated as much to yourselves. But before we started here, he said to me, Advocate Hali SC said to me, in fact, he's still here, but is not coming into the chamber. The situation as it stands is that she's not here because she's asking to be excused and that she wants to seek legal counsel. That is as far as I can take it, Madam Chair and your two sisters.
She's asking who to excuse her?
I understood Advocate Hali SC to be meaning the panel to excuse her. That's my understanding. I may be wrong in my interpretation of the message.
Assuming she sought our indulgence, she decided to leave the panel's permission.
That seems to be so, Madam Chair, because she's not in this chamber. And we are told she's still outside, but she's not ready to come into the chamber, or is not willing to come into the chamber, whatever the case may be.
If she is still in the building, she must be called.
I think I agree with that proposition.
Advocate Batohi, who is still on the witness next box, be called to the hearing chamber. I see your attorney, Ndatesimele Major, has just entered the hearing chamber. Do you know where Advocate Batohi is as you just entered? You may just speak to counsel. Come over. You are an instructing attorney. Speak to the evidence leading team. You are an instructing attorney and tell us where Advocate Batohi is.
Thank you, Madam Chair. Mr. Sebelemeta says to me that she saw her in the room. And I ask her which room. She says the room in which she sits.
Good afternoon, Advocate Batohi.
Afternoon, Judge.
We have just been informed when we were about to come here and resume that you decided that you are not coming back because you would like to go and consult counsel, correct?
That is correct, Chairperson.
And you decided to stay away without seeking our permission before you left.
I decided, Chairperson, that I was not going to come back pending getting proper legal counsel.
And you made that decision without us giving direction or permission for you to leave whilst you are still being cross-examined.
That's correct, Chairperson.
Why so?
I think it's an important decision and it's one that I need to take myself.
I'm not asking you about your decision. I'm asking you, you are before us and you decide that you are leaving without approaching us with a request or an application through your team to give you that permission, and you stay away.
Chairperson, I wasn't seeking permission. It's something that I decided I needed to do because it is about me and my integrity.
So you can do whatever you want without approaching us.
Chairperson, I didn't want to come here because I did not want to be subjected to this kind of questioning. I would appreciate it if I can be excused now.
I'm asking you questions first before we excuse you. That's why we called you back to the hearing chamber, because this inquiry is instituted at your instance, and we have been appointed to preside over this inquiry. And you decide, totally disregarding this panel, and to walk away and not decide not to come back here.
Chairperson, I was in the building. When I was told to come back, I did come back.
Do you want to walk away now?
I would appreciate it if I can be excused.
This is the request that you ought to have made before you behaved the way you did.
Understood?
Advocate Mutemanyane, before you speak, let me just give a chance to my colleagues if they have any question.
Advocate Batohi, as a lawyer and a senior advocate who heads a very important institution, the NPA, surely you know the rules. I know this is not a formal court sitting, but you know the rules of a quasi inquiry like this, and you know that you can't just walk out, especially if you are under oath and a witness. I take it you know that it's common cause, because you are a seasoned practitioner.
I understand that that will be generally the case. This is, in fact, you're correct, it's not a court. Appearance here is voluntary. But because of what I've been subjected to, I felt I needed to get legal advice, and that is something that is my decision. And as I explained to my counsel, I am not prepared to continue. I'm not withdrawing. I'm not prepared to continue pending getting good legal advice. And that is why I thought it was my decision to decide not to continue.
But Advocate Batohi, you cannot say it's voluntary, because the whole trigger for this inquiry is your referral to the president in terms of a certain section of a statute that governs you. So we are here because of an act of parliament.
Understood?
We are not just here as a kangaroo court where one can say, no, I'm not going to participate. I've heard it and. But we are here because you took time to write a letter to the president and referred the conduct or whatever of Advocate Chauke. And the president then constituted this inquiry. And you came here to testify, to give your side of why we are here. So if you feel I don't want to be here, I'm walking out, doesn't that border on being disrespectful to this panel?
I didn't intend to be disrespectful, and I'm not walking out. All I'm saying is that I'm not prepared to continue testimony at this point, pending getting legal advice.
Advocate Batohi, when we adjourned for lunch, you did not request to be excused. Is that correct?
That's correct.
And you were expected to come back after lunch like any other party that is here and participating in this inquiry.
That's correct.
And you then decided to inform the representatives of NPA that are present here that you are not coming back.
That's correct.
And true to what you had requested or what you have informed them of, when we resumed, you did not come back.
That is correct.
And you knew that we had resumed.
I had indicated to my counsel that that is what I will do. I was not going to come back. So I imagine that that would have been communicated to the panel.
And over the period, for the duration of this inquiry, any of the active participants in this inquiry would ask to be excused if the party or the participant would not be able to sit through the inquiry. To make an example, there's a time when Advocate Skosana left, there's a time when Advocate Hali left, there's a time when Mr. Nkabela left. In all those instances, they would have requested the inquiry to excuse them. It would be on application. Is it correct?
In my view, the circumstances are different, but you are correct.
They would leave after having been excused, or they would be absent after having been excused because they would have asked to be excused in advance.
That is what has happened. That's correct.
And you found it proper not to even come back when we resumed to ask to be excused.
In the circumstances which are important, I communicated through Karen to my counsel to inform the panel of what I had decided. And that was out of respect. I didn't want to just disappear. But I remained in the building as well. I was in an office. And when I was asked to come back, I came back.
Had you not been requested to come back, would you have come back?
No.
Thank you.
May I now be excused, Chairperson?
Do you really seek our permission?
I do.
Because I want to ask you a quick question. You told your counsel, it's not like you are requesting him to make an application. You were telling him that you are not going to come back, correct?
That is correct.
Did counsel had a choice to say to you, not this way?
We didn't speak much. I told him that and he left.
Because you were telling him, you're not seeking his counsel as your counsel.
I couldn't seek his counsel because I'm not allowed to speak to him. So I informed him that this is what I was going to do, and I was going to get legal advice, not from him, but legal advice.
Well, if you could not speak to him, couldn't you then wait and speak for yourself?
Chairperson, I wanted him to communicate that.
So he had no choice but just to tell us what you wanted or what you had decided, correct?
If you put it that way, then that's true. I suppose he had no
What?
choice. I don't know.
If I put it that way, is that how you answer?
I don't know if he had a choice or not, Chairperson.
You told him to tell us, not so.
Chairperson, I will not be shouted at here. I'm trying really to
You
help.
have been totally disrespectful to everybody here.
Well, I apologize then,
And
Chairperson.
we have been so patient with you, disrespecting almost everybody. And this has gone into the record. We've been so patient with you.
It's not the sense I get, but it's fine.
Well, the record will speak for itself.
Indeed.
It has spoken for itself. And today, you decided to be totally disrespectful to this hearing.
That was not my
Not
intention.
only to us, but to everybody here.
That was not my intention, Chairperson.
Well, everything has always been that not being your intention. But the fact speaks for itself. You've been disrespectful.
I apologize for that. It was not my
Advocate
intention.
Musamanyani?
May I suggest perhaps that my learned colleague, Advocate Nkabinde Section, should also comment?
But I think in fairness, we need to know now with this posture, what is to happen to these proceedings? Because you decided to walk away. You are still under cross-examination. When do you intend to come back?
I have no idea. When I get legal advice, I will know what to do.
Are you making an application from where you are sitting to postpone the hearing sine die?
No, Chairperson, I'm not making any application.
You're just walking away.
I'm for now stopping my testimony pending legal advice.
And we don't know when you will be available to come back to testify?
That is correct, because I haven't yet got counsel. And if they need to read the record, it might take longer than, I don't know how long it will take.
I beg your pardon.
I have no idea how long it will take.
And being a very senior lawyer, you cannot even say, let's postpone to such and such a date, given the fact that you are under cross-examination, correct?
I would propose sometime next year, given that it's the 15th of December already.
Advocate Mutlamuyani, if you, well, you had already said that Advocate Batohi will place whatever he plays on the record.
Thank you, Madam Chair. Advocate Batohi, I'm still cross-examining you. I just want to understand what you want to do. Are you prepared to answer further questions?
Not at this stage.
All right. So when will you be prepared to answer further questions?
After I get legal advice and I know what to do.
Just tell me something more about that. The Advocate Chauke is here because he's been brought here by you via the minister and via the president. And you have made no application for a postponement, but you are absconding from participating.
I'm not absconding. I need legal advice on.
Well, you may have a
next
reason for the absconsion, but you are absconding because you are not prepared to answer further questions.
I am not absconding. I am, at this point, not continuing with my testimony pending legal advice.
No, yes, what I'm interested in, it was my turn to ask you questions. You answered questions for 3 weeks.
Chairperson, I'm not prepared to be cross-examined at this stage on this. That is my decision, and I'm not going to answer any further questions.
Yes, that's exactly what I'm asking you is, you will not answer questions from me, you won't answer questions from the panel, and I'm not here in my personal capacity, I'm here on behalf of Mr. Chauke. So you will not answer questions raised on behalf of Mr. Chauke either, correct?
I'm not answering any further questions.
Yes.
This is my last question that I'm going to answer, and I'd like to be excused.
Yes. Well, the last time, Advocate Batohi, somebody walked out of an inquiry, there were serious consequences. But I have no reason to give you legal advice. Thank you, Chair.
Advocate Mutlamuyani.
This puts everybody between a rock and a hard place. But may I make the following suggestion, and my learned colleagues will comment if necessary. Seeing that we had already made arrangements for Wednesday on a substantive application, my suggestion would be let's reconvene on Monday, on Wednesday, and deal with whatever issues have to be dealt with. For instance, the issue of how many witnesses each party intends to call, and whether, and the application, the substantive application that has been made, and other relevant interlocutory issues. That is just how far I can take it, Madam Chair.
Madam Chair,
My learned colleague seems to be
is,
in disagreement with me.
I'm shaking my head vigorously. Could I just ask for a short adjournment? Then maybe we can agree a way forward. Because a short adjournment of 15 minutes. Ms. Batohi must take a decision about what she wants to do. She, as I understand, she has not been excused by the panel, but she's got lawyers to advise her. But insofar as the further progress of these proceedings, I would really ask for a short adjournment. I also need to speak to Mr. Harley, who's here for the NPA. Thank you, Madam Chair.
Yes, thank you. I was actually going to say, and I'm sure I'm speaking on behalf of my sisters, Advocate Mutlamuyani, the substantive intellectual application was going to be considered whilst these proceedings are underway. So it's not like we wouldn't deal with the substantive application whilst the cross-examination is continuing. We will still be here to do the work of the inquiry. As far as we are concerned, there's no proper application for a postponement before us. And Advocate Batohi says she has made a decision. She's not going to answer any question, meaning she's doing whatever she's doing on her own frolic. We have not given her permission. I suppose the teams will be given an opportunity to confer with one another about the next step that you propose should be taken, and we will consider that. We will adjourn Advocate Nkabinde for how long?
Well, it's between 15 and 30 minutes. Mr. Hale says 15. Mr. Matlamanyana says 30 minutes. I think maybe.
Let's adjourn now for 30 minutes. If you need more than 30 minutes, you will send a message to us to come back.
Indeed, thank
We
you.
will adjourn. Good afternoon, everyone. Advocate Mhlamunyane.
Thank you, Madam Chair. Advocate Tembas Kosana SC will address you.
Good afternoon, Gates Kosana.
Good afternoon, Madam Chair. Madam Chair, I've been given this difficult task to try and explain and also the view that we take of this matter subject to the panel's view as well. Madam Chair, we as evidence leaders, I think to some extent also with Advocate Ali SC, we were all taken by surprise by the decision made by Advocate Batohi. We had prepared, or were in the process of preparing witnesses as well as a list of witnesses. At this point in time, if it comes to that point that we have to call the next witness, we would in any event not be in a position to do so, looking at the time of the year and having spoken to some witnesses and tried to make arrangements with them. So, Madam Chair, would ask in the circumstances that first of all, we ask the panel to adjourn these proceedings, and perhaps I'll deal with the issue of the interlocutory application that is pending. But first of all, to ask this panel to adjourn these proceedings, perhaps to next year, to whatever date that may be agreed. At this point in time, we are suggesting the 26th of January, 2026, with a view that perhaps in the process, while we will be preparing witnesses and exchanging lists of witnesses, we hope also that in the process, perhaps Advocate Batohi may be advised to return back to continue with her evidence, which was under cross-examination at this point, after she has obtained the legal counsel that she seeks. Of course, we cannot guarantee that. We are not involved in that process. As the panel may know, we can't speak to her. We have not been speaking to her. As far as the interlocutory application, the papers, meaning the affidavits, have already been filed and completed. Today, the replying affidavit was filed. All that is left now is for us to make written submissions, which we intend to file not later than the end of the day tomorrow, the 16th of December. And perhaps ask the panel whether the panel can deal with the matter in chambers and give directions in regard to the proposed amendment, which can then be submitted and given to the parties in writing. But for now, then ask that the proceedings be adjourned. We have also looked at a number of ways to try and see how we can exchange documents with a view to limit some or eliminate some of the evidence that would have had to be led, that is now between the parties. But we will engage in that process during the course of the recess and before our resumption next year. So that, in short, our submission and our suggestion in the circumstances that we find ourselves. Thank you, Madam Chair.
Thank you, Advocate Skosana. The replying affidavit to the substantive application, has it been filed?
Yes, Madam Chair. Our attorney, Mr. Sibele Meza, advised me that that has been done. It has been served on the Secretariat as well.
When did you file it?
It was this morning.
Today.
Today, early today.
And the heads of argument?
We-
When do you propose to file them?
Well, certainly from my side, they will be ready by tomorrow. Before the end of tomorrow, we will file them.
Tuesday, 16 December.
Yes.
As you recall, we spoke about the list of potential witnesses this morning so that we may decide more or less which period we should request from the minister or from the president to extend the period that was initially allocated to this inquiry. The initial period was to end by end of January, meaning that when you approach the minister, we should have an indication at least approximately when we should end and submit our report. But we can do that, as we mentioned to you earlier, that you should indicate the witnesses, that number of witnesses you wish to call and how long each will take so that we can make an approximation when we will be able to finalize this inquiry. Have you discussed that?
Yes, Madam Chair, we have from our side as evidence leaders, we have discussed that the list has been prepared, but I have been informed that there has been some adjustments to the list, actually in addition of one or two names. We intended to finalize that not later than Wednesday, this Wednesday. Perhaps in the circumstances that we find ourselves in, we can even finalize it, I believe, today or tomorrow and submit it together with the heads of argument. I've just haven't discussed it as to the the time within which we intended. Had this not happened, we intended to submit that on Wednesday, but maybe we can try and do that earlier.
Well, as you know, we had indicated to all of you that we will sit until Friday, the 19th. But because of this 10 of events, it means we will adjourn earlier. But we need to have all that information at our disposal so that when we make a request, we should be basing it on information from your side. Yes, thank you. Advocate Nkabinde.
Thank you, Madam Chair. There are just 4 points. The first one is that we don't necessarily accept that Advocate Batohi is entitled to return and continue with her evidence. We will submit in due course that a witness who refuses to answer further questions in the middle of a cross-examination and then abandons the inquiry without leave has waived their right to participate in that inquiry. But that is not for today. It is simply to record that we are not ad idem with the evidence leaders about Advocate Batohi's entitlement to return. She did have options. Her option was not merely to leave if she was uncomfortable, either with a question asked by us or with a question asked by the panel. It happens quite often that a witness in the middle of cross-examination requests an opportunity to consult. And if on our side we are unreasonably withholding that opportunity, the panel is entitled to intervene and release the witness for consultation. But what has happened today has been the most extraordinary thing, where a witness has taken it upon herself to make those determinations. So there are consequences to that, which we will address in due course. So we should not be seen, when we cooperate with the approach proposed by the evidence leaders, to waive any of our entitlements, to ask for an entire striking of the testimony that she has given thus far. Number two, we agree with the postponement to the 26th of January 2026. Number three, we also agree that the interlocutory application should be decided in chambers rather than orally argued. Our heads of argument will be ready tomorrow. Junior will tell me when exactly. but certainly during the course of tomorrow. And we are ready with our list of witnesses. Like our learned friends, we have added one or two. And how many statements are there? And 4 of the witness statements are ready. And those can be exchanged as probably by Friday. Thank you, Madam Chair.
I think it will be prudent to give us an indication, at least by Wednesday, with regard to the witnesses, as we spoke earlier this morning. Because the next time we will meet, as you propose, will be towards the end of January, 26 January. And have no reason to believe that given the circumstances, it is not a reasonable period within which to do the necessaries. So we propose that by Wednesday, you give an indication as to the witnesses and the time they may take, so that we can make an estimation of the period the inquiry will need to finalize its mandate. Well, is that doable?
Indeed, Madam Chair.
Advocate Gauteng?
Indeed, Chair.
Thank you, Council. Your request to consider the interlocutory application in chambers is accepted. We will await the heads of arguments tomorrow, both of you before the end of business.
Thank
And we will consider the application and make a decision in chambers. The decision will be circulated to you by Friday. By Friday, the 19th of December, 2025, before we adjourn. As regards the request to adjourn these proceedings in the light of what has taken place this afternoon, a situation that we find extraordinary, we will adjourn these proceedings until next year, 26 January 2026. And if there's any application that is to be lodged in between, any such application should be filed online and will be considered appropriately. In that event, we will adjourn until next year. We meet in 26 January 2026, and we wish you a Merry Christmas.
Thank
and
you.
a very safe festive season to all of you. Hoping that when we reconvene, we will all be in good spirits. There is a birthday cake pending. One of the panel members promised all of you a birthday cake. It's her birthday tomorrow, so we had hoped to invite Advocate Batohi to a birthday celebration on Wednesday. But she decided to leave, and it's also the birthday of Advocate Nkabinde, and she has been ordered to provide a cake for all of us. Now, I don't know what is to happen to these offers, because we are told that we cannot proceed with our business. But on Wednesday, there will be a birthday cake to share. Those who are keen to come and share and celebrate with us, do come. Thank you. Advocate Nkabinde?
No, Madam Chair, it's just to express on our behalf at least the appreciation of how far we've come. We resisted at the beginning, but I think we saw the wisdom at a later stage. So we just want to wish the panel all the best for the festive season.
Council, yes, sometimes things are unforeseen, but all of us have been on it, and we have made a bit of progress, albeit at a very slow pace, but we have started. We account to the public, and whatever we do must remember that the public is awaiting our decision about these matters. Advocate Skosana, do you wish to say something?
Yes, I'd like to concur on behalf of the evidence leaders to also wish the panel the best, having joined these proceedings in the middle. I also like to say that I do appreciate the manner in which they've been handled, and a lot that I am learning. And I'm also privileged actually to be part of these proceedings. And thank you very much, Madam Chair.
Thank you. Let me thank Advocate Halley. Would like to say a word or two? We've been slogging on this matter from the beginning, all of us. You may speak to the mic. You have been part of this family from the beginning. It is a promotion.
Thank you, Madam Chair. Madam Chair, on behalf of myself and my junior, we wish to convey a Merry Christmas to everyone and a Happy New Year. I take it in the current spirit that I will be allowed to speak in future. So my application will be favorably considered. But thank you very much, Madam Chair.
Sure. Thank you very much, Advocate Halley. Place your application before us.
I thought my application was approved without me having to apply for it.
You know how it works. You have to persuade us on paper, and we may be minded to grant you the relief you seek. But I think it's opportune for me, on behalf of myself and my two sisters to thank all of you who have assisted us to be where we are today, the department, the state attorney, advocate, and Dr. Smelemech. Thank you very much. And everybody concerned, our transcribers, thank you very much. You have done a sterling work because we have been receiving transcribed records every day in the morning. We are thankful. Let me thank our spokesperson, Dr. Raleboch, for the assistance. Members of the media, all of you, members of the media, for your cooperation, for walking the journey with us. We have not had the challenges with you. We've worked so well together. We wish you Merry Christmas and hope to see you next year. Hope we have not trampled on your toes. Let me thank our researchers. Thank you very much for the assistance you have given us. Members of the NPA, Karen, thank you very much, and your team in the office for having assisted us. We know that we started late. You know why, but nonetheless, you have really been helpful. We appreciate that. And everybody else who has been part of this family. We as you know, Dr. Chauke, have they told you that in chambers we give hugs because we are a family? You have mixed a lot of hugs. I think when you reconvene in January, you are the first to come and get the hugs after a new year. But thank you for having been here from the beginning, every day attending the hearing. We really appreciate your cooperation with your legal team and your attorneys. They have all been sitting here. Thank you so much. I think I've spoken on behalf of my sisters, and we definitely wish to thank you. But the last people we have to thank, Mojamorago ke kgosi, in Setswana, that's what they say. I don't know what is the literal translation. The one who is last is a king. Our protectors, ladies, thank you very much for having made it possible for us to come in and out of this place. And we look forward to seeing you again next year. Thank you. We will adjourn, and all the best. Safe festive seasons to you and your families. Thank you.